From Cafe and the Vox Media Podcast Network, welcome to Cafe Insider. I'm Elie Honig. This week, I'm joined by Trevor Morrison. Trevor is a law professor and Dean Emeritus at New York University School of Law. Trevor and I will be discussing the DOJ policy against indicting or prosecuting or imprisoning the sitting president. Policy goes way back to 1973 in the Watergate era, and it has remained the official guidance ever since. Most recently, it has come into play in the Mueller investigation, and now it is impacting Jack Smith's two cases. Legal nerds of the world rejoice, because if we got the perfect episode for you, Trevor, that is not a reflection on you as the guest. That is a reflection on me and our subject matter today, which is this DOJ policy that has really been one of the most high profile and I think controversial and really widely disliked or maligned policies that we have on the books. So let's start with the basics. Can you walk us through basically where this policy comes from and what essentially does it tell us?
Sure. I'm very glad to join any conversation among law nerds. And this is an important and interesting issue, as you say. So the question whether a sitting president may be subject to federal criminal charges is an old question. And there are kind of two key moments in the Justice Department's history of when the question was addressed. The first came in 1973 in the context of the Nixon administration, and the question whether President Nixon might be subject to indictment and even prosecution in connection with the various investigations involving him and those close to him at the time. And the Office of Legal Counsel within the Justice Department, which is the office that you would expect would address a question like this, in 1973 issued a very long memo concluding that sort of basic constitutional separation of powers principles precluded the indictment and prosecution of a sitting president. It was focused narrowly on that question. It was a temporary immunity, as the office said. This was not about the extent, if any, of the president's immunity from charges after he leaves office. This is just while sitting. To that extent, though, it also didn't turn on whether the president would be prosecuted for things he did while in office or whether these charges would relate to, say, private conduct before he was in office. It was about an immunity that attached to the time while he was president because of a concern that having to deal with any criminal charges during that time would really untenably interfere with the discharge of his duties. Now, 2 weeks after that, Solicitor General Robert Bork agreed with that position in a brief that was filed in a court case in district court in Maryland, responding to Vice President Agnew's attempt to have a grand jury proceedings against him dismissed. And Bork said, this is the rule for the president and the president only. The vice president and everyone else in the executive branch does not enjoy this temporary immunity.
First of all, when you mentioned the Office of Legal Counsel, sometimes this memo is called the OLC memo, the OLC policy. This is a collection of geniuses within the Justice Department. I was never allowed anywhere near them. I don't know exactly who they are, but they're the people who wrestle with these extremely thorny, often unknown issues of constitutional law. My understanding, and it's a little fuzzy in the historical record, I was under the understanding, and maybe this is from the podcast that Rachel Maddow did about Agnew, is that the actual impetus for the researching and drafting of that memo was not so much Nixon. At the time, they weren't thinking, well, they were thinking he could possibly be thrown out, but they were actually more focused on Agnew. And the memo in 73 comes back and says sort of good news, bad news. The good news for all of you is the president cannot be charged, the sitting president, but the sitting VP sure can, which is what led to Agnew heading out with his sort of plea deal in place.
That's exactly right. Your general description of OLC, I think, is entirely correct, with the exception of me. I served in OLC, and so I won't take the genius description there. But I think that's right. It was clear at the time that OLC put together this lengthy memo, which would have taken at least weeks to put together, that the issue was about to be called in Agnew's case. It wasn't totally obvious that the issue would ripen in Nixon's case, but in order to figure out the answer to Agnew's question, I think you had to figure out the answer to Nixon's question. You're going to have to figure out, what do we think about these offices? Do they need to be treated similarly, or is there justification in treating them differently? And as you know, I think the answer was reaffirmed by OLC in 2000, in the last months of the Clinton administration. That happens to be a time when I was serving in OLC, but I didn't work at all on that memo in 2000. And OLC really reaffirmed both the conclusion of the 1973 memo and the reasons for the conclusion, that it was a kind of general constitutional separation of powers concern with undermining the effectiveness of the presidency, which would come at a cost to the country and the national interest. And so for that reason, OLC emphasized this was a temporary immunity. In fact, if you read between the lines of that memo, I think that it's fair to draw the inference that OLC anticipated that a former president would be subject to criminal charge. Of course, the Supreme Court has taken a rather different approach with its decision last July. OLC didn't directly address that question in the 73 memo or the 2000 memo, but in 2000, it reiterated and reaffirmed the position it had taken, almost 3 decades earlier.
So I'm going to break a little bit of news about that 2000 memo right here on this podcast. Now, it's 24 years later, so I'm not sure how breaking it is, but I am in the process of researching my next book, which is going to all viewers, cafe viewers, prepare for this. Comes out sometime in 25. But it's an overview and assessment of the way that the Justice Department has used independent counsel, special counsel from pre-Watergate on through Jack Smith and whatever may come next. And one of the things I learned is I talked to this guy, Bob Ray, who replaced Kenneth Starr as the independent counsel when Kenneth Starr sort of reached the end of his line. And Bob told me, and this is going in the book, that the reason that 2000 reevaluation happened is he, as the independent counsel, this is after the impeachment, he was trying to signal to the Clinton team, hey, I'm serious about this. Like, I will indict you if I need to. And the way he did that sort of diplomatically is Bob Ray, as independent counsel, went to Eric Holder, who was then the deputy AG, and said, I would like you to reassess that policy and let me know if I'm allowed to indict the president now or if I have to wait until he leaves office. That spurred DOJ. They then did the 2000 reexamination, which you just described, and they came to the same result. So that's a little bit of a mystery, minor mystery, but a mystery solved about why in 2000.
Super interesting. Well, I think there was a general sense that as the administration came to a close, that these questions could ripen. Could any criminal process be initiated if it were warranted against the president while he was still in office? And if he was not, impeached and convicted on the impeachment, is there anything that, any bar on what could happen to him after he left office? These were all swirling around. I didn't know that actually Ray was the one who sort of, literally prompted OLC to provide the opinion. That's interesting and juicy.
Yeah, good. Okay, good. I'm glad that wasn't already publicly known. Now it is, but it'll be in the book, along with many other good tidbits. Okay, so this policy obviously gets a ton more attention. It kind of goes largely unnoticed between Clinton and the Donald Trump era. But now it's been, over the last several years, it's been in the news twice in a very big way. Once, of course, was in relation to Robert Mueller. Mueller wrote in his report and testified that because of the existence of the policy, that is why he never reached a thumbs up, thumbs down determination on whether Trump committed the crime of obstruction of justice. People didn't like that. People were frustrated with that, myself included. I get it. And now it's back in the news right now because, as we've seen reporting, Jack Smith is packing up his suitcases and getting ready to leave. And I think there's a little bit of a misperception because, yes, Donald Trump has said, I would fire Jack Smith within, quote, 2 seconds. And no doubt he would. But in my understanding, and I want to hear your reaction to this, even if Donald Trump said, that's not the actual reason Jack Smith is getting ready to leave. I don't think Jack Smith's leaving because I don't want him to fire me. The reason Jack Smith's leaving, and you can see this in his correspondence with the court, is because, in his view, the policy we've been discussing precludes him from carrying through with the prosecution of the sitting president. So even if Donald Trump said publicly, I'm going to let Jack Smith do whatever he wants, I'm totally hands off, I still think Jack Smith would be packing up right now because of the policy. Do you agree with that?
I do agree with that. Yeah, I think special counsels have correctly viewed themselves to be bound by OLC's position on this issue. It represents the Justice Department's position on this issue, and therefore all special counsels are bound by it. And so exactly right. If after inauguration, Donald Trump just let the special counsel sit there, he would be, with respect to these charges against Trump anyway, just in a kind of paralysis for 4 years. And so the alternative is for him to file a report, as the special counsel regulations contemplate, with the attorney general, summarizing the results of his investigation. And I expect that Jack Smith will do that before the end of the Biden administration. I see no problem with that report reflecting his conclusions about at least on his analysis, the criminality of Trump's conduct. We can debate whether Mueller was justified in sort of extending the principles, I guess he thought, of the OLC memo to say in that context that he couldn't reach a conclusion. In my own view, that's overreading OLC's position. And I think Mueller was not required by the OLC memos to refrain from reaching a conclusion as to the criminality of Trump's conduct in the context of the Mueller investigation. But even if he was, we now do not have a sitting president until January 20th. And if Jack Smith files his report before then, as I expect he will, I would expect it would reach conclusions.
So interesting. So you are of the view that Mueller was not compelled to do what he did, that he could have, if he wanted to, have said, in my view, while I cannot charge the sitting president here in 2019, I do believe that the conduct here would satisfy probable cause and would be indictable for obstruction. Do you think that would have been okay under the memo?
I think, yes, I think that's a matter of discretion. And you surely know better than I do that there are reasons why prosecutors in general don't say, I think I've got chargeable criminal conduct here publicly, and then do nothing about it. But I think it would also be understood that this is an unusual and special case. And you could, I think, understand why the special counsel would find it important to reach that conclusion and communicate it to the attorney general. In the first instance, the report would go to the attorney general, and that to the extent that became public, the public could then know where Mueller was on that question. I don't think the OLC memo precluded him from doing that.
Very interesting. And I think I agree with your take on that. Okay, I have two very big and somewhat interrelated questions for you that are sort of, I think, the big questions on everyone's mind. Why does everyone hate this policy so much? And is it right?
Let me take it in reverse order, if you don't mind. I do completely agree with this policy.
So do I.
It's a policy to the extent that the Justice Department has adopted it. Because of the policy, at least as a matter of federal criminal charges, it makes it extremely unlikely that a court would ever have occasion to opine on whether it agrees with the policy as a matter of constitutional law, because the policy tells you there's not going to be a federal case. It is imaginable that the similar question could arise with respect to state criminal charges, since this policy does not govern that. And if it does, I expect that the ultimate answer that the judiciary would provide, whether state judiciary or federal judiciary, is that the constitutional separation of powers preclude indicting and prosecuting a sitting president for state or federal criminal charges. So I think this policy actually reflects sound constitutional separation of powers concerns. The top concern being that the office of the presidency is a unique office in our system and has unique burdens and responsibilities, and that the national interest would be disserved by having a president sit to face criminal charges while in office. If that meant that because of statute of limitations or something like that, the president was totally unprosecutable after, even for private conduct, I think that would be an unintended and unnecessary consequence of the OLC memo. We can think about tolling statutes of limitations or equitable doctrines of laches and the like, ways to preserve the possibility of prosecuting the president after he leaves office. And I think that's the way to go. If the criminality is so severe that it requires removing the president from office, cutting his term of office short, then the remedy for that is impeachment within the Congress, impeachment in the House, and trial on those articles in the Senate, not prosecuting him criminally in court. Why do people not like it so much? I think it has a feeling of placing the president uniquely above the law. It's the same reason that so many people chafe at even the idea of any post-leaving office immunity for the president. My own view there is that the president has some degree of immunity from criminal prosecution, but that the majority of the Supreme Court went way, way too far in how it articulated that. But I think it's the same discomfort, and I get it. And I'm sure you do too. The idea of immunity, especially when it comes to the criminal law, seems to smack of placing this person above the law itself. And we don't have a system that does that. So we have to be very careful about the metes and bounds of this immunity, but a carefully drawn one, which is what I think OLC has articulated and defended, seems to me exactly right.
Yeah, I actually didn't know where you were going to come out on that. And I come out in that it's right, and maybe even more so than right. It's not as if there's some discernible, correct constitutional answer. As to me, it's just a practical question, right? Like, how would this work exactly? We would have a commander in chief potentially behind bars. And if you look at the memos, one thing that strikes me is they do look the part, right? They have nice citations and discussions of the Federalist Papers and Madison and Hamilton and all these sites, but really at the bottom, they're practical documents. Really, how would we function realistically, And I think you hit the nail on the head as to why people hate this policy. I mean, exacerbated by recent frustrations with Mueller and now with Jack Smith, not with the individuals, it's not their fault, but with what happened on the Mueller case and the Jack Smith case. And I think it's interesting that, this policy has become a sort of convenient political scapegoat. It became very trendy in the wake of Mueller for leading politicians to bash this thing, right? Why not? Because as you said, who likes the idea that somebody's above the law? I'll give you a couple of examples. These are things that people said shortly after Mueller came out with his report and his testimony. Adam Schiff said to CNN, to Wolf Blitzer, quote, "I think the Justice Department needs to re-examine the OLC opinion that you cannot indict a sitting president under circumstances in which a failure to do so may mean that person escapes justice." Jerry Nadler said a similar thing. Elizabeth Warren said, "Donald Trump believes he can violate the law and believes that the role of the Department of Justice is to help him get away with it. That's not how our country is supposed to work. I pledge to nominate an OLC head who will reverse the Watergate era rule that a president cannot be indicted for criminal behavior." Nancy Pelosi also said, quote, "I do think that we will have to pass some laws that will have clarity for future presidents. A president should be indicted if he's committing a wrongdoing, any president." Now, all of that was said by four of the top voices and most influential people in the Democratic Party before Joe Biden took office. Fast forward, 2021, Joe Biden comes in. You have a Democratic Senate for much of that time. You have Merrick Garland in the AG's office, and nobody makes a peep. Nobody, as far as any public record, maybe there was some deep cover review done that we haven't learned about, but nobody even said, hey, let's take another look at that 2000 policy, right? Why do you think that is? Why do you think with all this political momentum from the Democratic Party, they're frustrated, they come in, and nobody even wants to touch the thing?
I'm not going to malign any member of Congress about the good faith nature of their objections, but you should feel free.
I will. I am so maligning.
These things exist in a political context, but maybe one way to put it is sometimes I think genuinely held feelings that are fueled by a particular political context then can be rethought over a longer period of time. And I think you're right. I just want to clarify by my saying I think that the memo is correctly based in principles of separation of powers. I totally agree with you. It's not like there's some text of the Constitution that we can explicitly hang our hat on here, but that's actually a familiar thing when it comes to trying to figure out the constitutional separation of powers. One of the great judicial opinions on the separation of powers of the 20th century, Justice Robert Jackson's concurring opinion in Youngstown, the steel seizure case, said, it's striking how few judicial precedents there are and how little constitutional text there is to go on when you're trying to figure out the metes and bounds of executive power. And this issue is sort of in that family. So we have to figure out the right answer without the benefit of clear text or easily governing precedent. And I can imagine that some of the folks in Congress you mentioned or their staffers could have had conversations with folks in the Justice Department who would say, look, as a matter of constitutional principle and, as you say, as a practical matter, there just really can't be any other rule. The 1973 OLC memo spells this out. I mean, you would effectively be having the president be on both sides of the V in the case. The president would be the defendant, but he would also be atop the branch of the government that was initiating and running the prosecution. And the idea of, being a judge in your own case is a bad idea, but probably being a prosecutor in your own case is also a bad idea. And that's a more kind of practical thing that OLC recognized in both of the memos.
I think that's right. And I suspect if you talk to all the very smart people, Adam Schiff and Elizabeth Warren, they would tell you, of course, how could you really have a president? I mean, that would be, look, I know there's a lot of frustration, but if you're, let's say, if you're a Democrat, if you're somebody who dislikes Donald Trump and you hate this policy, consider this. Remember Robert Hur, the special counsel who investigated Joe Biden on classified documents, right? There's a way you could read Robert Hur's findings to say that, well, a reasonable prosecutor, I think Robert Hur did the right thing. I think it was right not to charge, but you could read his findings and say a reasonable prosecutor could have indicted Joe Biden. Let's assume the facts were a little different. Let's assume Joe Biden's possession of classified documents was a little more flagrant, a little more knowing, whatever. If you hate that policy, that means you would be okay with Robert Hur indicting Joe Biden. in 2023 while Joe Biden's in office and potentially trying and imprisoning him while in office. So it does run both ways. I'm not saying what Joe Biden did should have been indicted, but if it was, let's say he had done 20% more and it should have been indicted, then you have to be okay with that if you want to do away with this policy. A couple of quick things I want to make sure we cover here. Civil lawsuits, all the E. Jean Carroll, all that, there's going to be normal appeals on those, but unaffected by the policy, correct? And perfectly permissible under the Paula Jones decision.
That's right. I should clarify, I was part of the legal team representing E. Jean Carroll at trial in both of her trials against Trump. But that's right. Those appeals are pending, and I don't think anyone thinks that there's a kind of, once the president is in office, he's immune. In fact, he's the one initiating the appeals. But under the Paula Jones case, you're exactly right. And this is reflected in the 2000 OLC memo. They just say there's a huge difference between civil litigation for conduct that's not official conduct. If it's official conduct, that involves Nixon versus Fitzgerald immunity. But if we're talking about not official conduct or a circumstance where the president just hasn't asserted any immunity, then the fact that he's in office doesn't stop civil proceedings that would otherwise be going forward from going forward. That's what the Paula Jones case stands for.
You've also a couple times mentioned, and you touched on briefly, would this policy bind state prosecutions? In other words, would this policy apply to prevent any further action on the Manhattan DA's case, the Georgia Fulton County case? I come out the same as you. I mean, it's almost like if federal prosecution is preempted, then there's an even stronger argument that you can't allow really, we're talking county level prosecutors here for a lot of the same reasons, plus the supremacy clause on top of it. I've heard some people trying to say, well, maybe there's a needle to be threaded and state prosecution is more amenable to go forward. I don't buy that at all. I think it's the opposite.
We'd have to acknowledge that state prosecutions don't have one of the problems we were just talking about before of the president being on both sides of the V, because it's a local DA who would be on the prosecutorial side of the V. But I tend to agree with you. We'd have to be thinking about principles of federalism and federal supremacy, and the idea that a sitting president could be subject to indictment and prosecution by hundreds, thousands of DAs across the country. I think that is, much more disabling of the office of the presidency. And so it's not that the OLC memo by its terms governs that decision. But I think the reasoning of the OLC memo would be very likely to be adopted and adapted to this sort of federalism context to preclude state prosecutions of a president while in office. Again, only while in office.
One more concluding question that's extremely timely, and it's only going to last another 60-some days, maybe 70 days. Do all of these protections afforded to the president also apply to the president-elect? Because this is what Donald Trump is now arguing, or soon going to argue, that all the hands-off rules that are going to apply to me on January 20th at 12:01 p.m., I'm now the president-elect. There is legal status around being president-elects. Various statutes do recognize that as a status. And I'm in transition right now, and therefore all the same protections, or is it different?
Well, I think this is fighting the question a little bit. The OLC memos themselves don't really anticipate that situation. They talk about being in office. And even though, the day after you leave office, you were very recently there, I think the memo doesn't apply to that time period. And so technically it doesn't apply during the transition either. But there are huge practical problems. You'd have to envision not only, beginning, but completing a prosecution in a very short period of time. If you could, I don't think there would be, in my view, I don't think it would be easy to justify some argument that the Constitution precludes process against the president-to-be. It's just as a practical matter, it's hard to see how you could actually complete it in time before you ran into this immunity. And so I imagine, for example, that that's part of Jack Smith's thinking, that there's really nothing more he can do at this point before the immunity is going to kick in.
And to speculate about the question you raised, which is, why OLC has never quite addressed this scenario, I think it's because, I'm guessing, in logical reasoning, ordinarily, a person who's already been indicted or already is in the criminal process would not really be a viable candidate to retain the presidency.
That's a very good point. Yeah.
I mean, both Nixon and Clinton were already president, and then they got in trouble, right? Watergate and Lewinsky. Here we have the opposite. We have a guy who's already was in a ton of trouble and then becomes president. As always, the only rule is Donald Trump flips all the rules on their heads.
That's a very good point. Randy Moss, who was the head of OLC during 2000 when that memo came out, he was my boss at the time. I can imagine that it did not occur to him to think about that scenario, that indictment would have been thought to have preclude the political possibility of entering into office, whereas here it seems like it was part of the reward.
It's a whole new world, Trevor. This was a pleasure. Thank you for joining me. And
thank you.
This is what a thrill. I finally have, you're the first person I've ever spoken to who's been in OLC. You're the first human being.
Proof of life.
I'm sure I'm exaggerating, but you were the geniuses who churned out the world's most difficult opinions. So thank you for that. And thanks for joining today. It was great.
Thank you.